This matter is before the court on the defendant's motion to show cause. I have reviewed the motion. I've also reviewed Ms. Anderson's answer. Is there anything else that you want to add, Ms. Huffman?
Not anything else specific. I just wanted to do a quick summary if I might, if the court needs it. Otherwise I won't, but
Okay, now if there's something you want to point out in summary, go ahead. I just don't need to hear the motion again.
Okay, so basically what I wanted to point out is that this 2 weekends in a row that this minor child has been trying to have parenting time. It's not like dad is preventing this. Dad is taking this child, but mom is refusing to allow the child to bring his phone, which this court has already ordered that he be allowed to bring his phone. So it is extremely detrimental to this child's well-being. We already have the one child refusing to go. And like I said, dad keeps talking this child into going, even though he's afraid to go. And his mom states in an email that she's afraid of the child as well. So I don't know what we're doing here, forcing this toxic situation to continue. It has to stop. It should not even be a question at this point. So we're asking the court to suspend parenting time at this time, or to order supervised parenting time with the maternal grandfather. Oh, sorry. And we would also ask for attorney's fees in this matter. I know we didn't specifically ask for it, but we did ask for any other relief the court deemed appropriate in the matter. And in that case, we would ask for $620 for the filing fee and the amount of time it took to do the motion.
Okay. Ms. Henderson, what's your response without reiterating your answer?
Thank you, Your Honor. In this matter, the court has ruled that the minor children are to have access to their mobile phones in the respective parents' home. My client has a separate phone to use for the minor children in her care. They each have a phone in her care. The court previously has ordered that the parties are to engage in co-parenting counseling with Dr. Haugen. My client has participated at this point in at least 3 sessions. The recommendation of Matt Bosher, to whom Dr. Haugen referred the counseling to, is that each party keep their phones at their homes, that the children have phones to use in their homes, but they don't take them back and forth to prevent the disputes about that, Your Honor. So she is following that recommendation. She informed Mr. Depew about that recommendation. We are unsure if he actually engaged in any sessions at this point, but my client has followed through with the order and has actively engaged in counseling. There is absolutely no evidence that parenting time is harmful for the children. And that is the standard that the court has to use when considering suspension of parenting time. We're dealing with a defiant teenager, or 2 teenagers at this point, Your Honor. Co-parenting counseling has been requested and ordered. My client is following through with that. So that is an issue that needs to be brought up and worked through the counseling rather than getting the court involved endlessly in this matter. One point that is asked for in the motion at this juncture is that Cameron is included in the counseling. It has been done, even though Mr. Depew did not specifically ask my client permission to enroll him in counseling, but the child is attending counseling, and my client is in touch with a counselor regarding the children's counseling at this time, Your Honor. Further, I want to point out that this motion is verbatim, a motion that has been denied a week prior with a different title. And that week prior, the motion was filed as ex parte motion to suspend parenting time. Your Honor, Mr. Depew is trying to cause my client further emotional distress, further disparage her in front of the minor children, and cause her additional attorney's fees, which we're requesting in the amount of $700 at this point. Further, Your Honor, we have included some reports that refute the statement that my client is abusive to the children or that she is not following the court order. That is simply not true. So at this point, Your Honor, we're asking for the motion to be denied in its entirety due to no harm caused to the children or no showing of that harm caused to the children. My client is following the co-parenting counselor's recommendations as she was ordered to by the court. And Your Honor, we're asking for attorney's fees to be granted due to continuous filings of the motions in court, even though this matter is currently being addressed by the co-parenting counselor, as was requested by the defendant previously, Your Honor. Thank you.
Okay. What the court's gonna do is the court is gonna order that the children, and that would include Cameron as well, would continue in with the present counseling. That the court would order that the children be allowed to maintain their phones while in the parent care of either of the parents. So if they want to take whatever phone they have from the one parent to the other, they have a right to do that. We'll put in that there was some issue brought up about the contact between the parents. The court will state that each parent is limited to one text or one call per day with the children, and the court will reserve on all further relief pending an evidentiary hearing in this matter, which will not be set until such time as we have some counseling and other report and recommendation from the counselor. So Ms. Huffman, you can prepare that order and submit it under 7-day notice. Court will end this matter at 10:47 a.m. You're free to go. Have a good day.
Thank you, you too.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This is before the court on the plaintiff's motion to set aside referee. Or set aside, is this the default or the referee recommendation? Mr. Jones, just so you know, as Ms. Podolsky has pointed out in her answer under Court Rule 3.215, that your motion has to contain a clear and concise statement as to any error that the referee made. You can't simply set aside the referee recommendation because you don't like it. You have to have some legal or factual basis. What is your legal or factual basis for seeking this to set aside the referee recommendation?
Well, there's a decision last year from February that it was just based on my residency. And then I come in with residency thinking that I could have my joint custody back. And then here now I'm being told that 1 month out of residency isn't good enough to have my joint custody back. So, I mean, I'm under a year lease. I've had my employment for 6 years. There's no reason why I shouldn't end up having my joint custody back.
Okay. Ms. Podolsky.
Thank you, Your Honor. There was a motion last year to modify custody, parenting time, and support. There was a full evidentiary hearing held. This decision was not based solely on the plaintiff's residency. It was a major factor, yes, but it was not the sole basis of that decision. The referee made a decision at this time that became the new order of the court. His current motion simply stated that he has a residence now and should have joint custody again. The referee agreed that that did not meet the standard as set in Vodvarka to change custody and parenting time. And now again, as the court has stated, this current objection, this motion to set aside the referee recommendation does not comply with court rule. It does not state a clear and concise statement of specific finding or application of law that the referee made that was an error. So we are asking the court to deny this motion and uphold the referee decision and continue the current orders of the court.
Okay, Mr. Jones, any response?
So, like, he was basically saying that 1 month isn't stable enough, but that's not written into law what is defined as stable enough. You know, I've been through this, the kids' life as a stable father. I've been here. I've been through athletics, traveling. I do my parenting time, Thursday dinners. Boys are no longer really children. They're adolescent young men. They need to be respected as where they would like to be, when they would like to be. They want to be back home with dad. You know, I get a home, like, here's a bedroom, brand new beds, Over at Sarah's house, they sleep in a basement. Torrin is sleeping in a closet in a bedroom without egress, without fresh air, like no windows, sleeps in a closet. But here, yeah, I get a stable home, and then where in the laws are written that there's a time period. Like, all I know is based on my residency. The time I had no residency last year, now I have residency.
Okay.
Like,
Well, what happens in this case, as you probably know, as the referee would have went over under MCL 722.23, there are 12 factors the court looks at to determine, again, custody in this particular matter. Again, the stable, satisfactory environment is just one of those particular factors. And you have not, when the referee, again, utilized that and said, well, that 1 month was not sufficient, the court cannot see any error on that particular factor based upon what you've presented in this particular case. There may be other factors. Again, stable, satisfactory environment is one factor, is one of the 12. And as a result, the court is not able to find error on the part of the referee based upon your maintaining residence for 1 month at the time of that particular hearing. Not to say that it couldn't, but again, that is only one factor under the again, Child Custody Act. And as a result, the court does not find any error by the referee. So the court will, in fact, deny the motion to set aside the referee recommendation at this particular time. And that will be the order of the court. We'll end this hearing at 11:05 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Magnuson in this matter on behalf of the front of the court. The matter is before the court on the plaintiff's motion to set aside referee recommendation. It basically states, Ms. Coleman, that again, you had some issue with regard to, or Mr. Coleman, you had some issue with regard to, again, the DNA and all of that. Is that correct?
Yes, Your Honor.
Mr. Magnuson, what's your position on this?
Well, Your Honor, what we could do, our office can facilitate genetic testing. This is an action under the Paternity Act. I would simply suggest that the order remain in place. It is a zero order, taking into account the defendant's incarceration status. And I believe that we could accomplish the genetic testing and take care of that issue while the order remains in place. And if there is an exclusion, we can deal with that down the road.
Okay. Plaintiff, is that something that's agreeable?
Yes, I would just like a genetic test of me and Kylan Samuel to
Okay,
be for sure that that is his son.
okay. Well, let's do this, and I guess I'll ask Mr. Magnuson if you could prepare an order for DNA testing and that the parties and the child would cooperate to accomplish that. We can get that done, that the order will remain in effect at this point until we get the results from the DNA testing.
I can do that, Your Honor. And I believe I heard Ms. Coleman indicate that Mr. Samuel had been moved to another facility.
She did early, yes.
Ma'am, if you could let me know what the name of that facility.
He just came back to Newaygo, in White Cloud, Michigan.
Okay, very good.
Okay, thank you.
Thank you.
Court will
Thank
end this
you.
matter at 11:08 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
This matter is before the court on the defendant's motion to set aside referee order in this matter. Again, sir, we don't set those aside simply because you disagree with the ruling in the particular case, but you have to establish that there's a factual or legal error for, again, for doing that. So what do you believe to be the factual or legal error that the referee made in this matter?
I'd like, the last time we hooked up, I wanted to get a DNA test. And my income, you guys got my income wrong.
Okay, well, let me tell you, Again, that's why we have hearings, so you can come there and present that. You weren't present at the hearing. So, I guess I'd say, don't look at it as our fault that we don't have the income correctly when you don't appear at a hearing.
Okay, what hearing was that, sir?
The referee hearing, the one that this resulted in this order.
Okay.
Okay,
Ms. Hunter, are you opposed to a DNA test in this matter?
Yes, I thought he did it a long time ago, but I guess he didn't.
Well, okay. To say I thought it would, we don't know. Okay, if again, he's claiming that there was no DNA testing, what happens, the court will order DNA testing in this matter of the parties and the child. And I'm not going to do anything with the order until such time as that DNA is completed, because if the DNA shows that he is in fact the father, then there's no reason to change it. Court will order at this point that Mr. Marchuk would be responsible for the cost of that DNA testing. Mr. Marchuk, I'll tell you, you can contact the front of the court, and sometimes in some types of cases, they can assist in having that, testing done. So again, it's be a minimal, if any, cost in this matter, but I don't know if you fit with under the provisions whereby they would in fact accomplish that. So you're going to have to, what you'll have to do is contact the front of the court's office, talk to a Mr. Magnuson.
okay,
He can tell you whether that would be something that the front of the court would do. Okay. If not,
okay,
then you're going to have to, then you're going to have to acquire the DNA test yourself at your expense.
okay.
Okay?
Yep.
Okay, we'll proceed to that point. That will be the order of the court. The court will end this matter at 11:19 a.m. You're free to go. Have a good day.